some companies wanted to donate say 10% or 15%. Correct? Now there was a cap, 7.5%. What used to happen was that company would create shell companies. So I would, as a main company, donate 7.5%, and from that shell company, I would donate 7.5% to make it 15. With a view to discourage creation of shell companies, we have said that it is the company doing the business through the managing director, through the board of directors, which are trusted by the shareholders. And therefore, if they want to donate more than 7.5%, let them do it. Let that discretion remain with that. As a government or as a parliament, it's none of our business to prescribe that ceiling. They don't use more than 7.5%. So that was the purpose. The purpose was to disincentivize creation of shell companies to do what they wanted to do. But now you do it.
But that
Number two.
You can disincentivize
Number two.
that
Allow me to say.
by having narrowly tailored provisions. For instance, that you must carry on business for a certain stipulated period. You must have a certain asset base. You must have a certain turnover. These are all, usually accepted yardsticks under the Income Tax Act to prevent a shell company from carrying on activity. That you must have a certain degree of business turnover, capital, assets before you can donate. That makes sure that you don't have a shell company. You can put all these things in place. There's no difficulty. That will obviate your concern of shell companies.
I bowed. But another thing which weighed with the government, and I'm just trying to satisfy your lordship's conscience about the positive approach with which, my lord, we approach this problem.
Mr. Solicitor, we don't have to go into the motives of the government at all.
No, I'm giving the reason.
I mean, the Constitutional Court is no part of our function to deal with motives. I mean,
no, certainly. Your lordships may even deal with
this is the rough and tumble of democracy in the country. Entirely respect. That's why we have this freedom of speech that all of us have in the court, outside the court. So we respect that process.
Which many a time
point is, but the point really is this. The point really is not that. We don't want to go back now to a cash-only system. No, that's not the purpose of the court. All that we are saying is that do it in a proportional, tailor-made manner which takes care of the serious deficiencies of this.
Now, my lord, another factor which weighed with the government while coming out this no cap policy was that if some party wants to donate more than 7.5%, and they do not wish to have a shell company also, what would be I'm posing a question to myself, what the company will do?
They will not donate.
No, that's the first idealistic option. But that was not, that didn't used to happen. What they used to do was, the balance, they want to donate 10%. The balance 3.5% would come in cash. Now at least, if they donate 10%, the clean money comes in the system.
Which is not to say that the unclean money is not coming into the system.
See, we are in fact going into there are two conflicting rights in a way coming from. One is confidentiality, the other is check on kickbacks or quid pro quo. These are times.
I would, my lord, earnestly urge. Lord, I would earnestly urge. Dealing with a subject matter which is bothering everyone, to start with a presumption that every contribution should necessarily be a part of corruption may perhaps be a wrong way of looking at things. It may be that in some cases it can be quid pro quo. In some cases. But the experience have suggested that in most cases, whoever donates, donors, be it individual contractor, businessman, company, trust, HUF, etc., they donate which kind of a government they want. Maybe out of 110, maybe kickbacks. I'll address that kickback part also.
Would that be valid if a company were to donate even 100% of its revenue? Is that guided by altruistic motives? We quite see. Everybody doesn't donate, as a kickback. Not at all.
Therefore, my lord, kindly, my lord,
And
do
we
not
also
see
have
this.
companies. We also have companies. All companies cannot be tarred with the same brush in India. You have corporate sector which has contributed to the productive assets of the nation.
But
So we're
look,
not.
they have
We're not at all saying that our
contributed
corporate
to the
sector is therefore
development
tainted.
of the
You
nation.
shouldn't make that assumption.
Well, only a minute, Mr. Sibal. Sibal, sir. No, there was something personal, not. It was not a fun or humor. my lord. Out of concern, I asked something, which I'll right now not share.
That's all right.
We had some concerns. I said, go to my chamber. That's all. Lord, so the idea was that instead of either shell company or paying by cash, let the clean money come into the system. And my lord, clean money has come into the system. Second, whether we like it or not, my lord, industrial houses, commercial houses, corporations, companies, they have, my lord, immensely helped. I'll explain the scheme. And my lord, possibly, at least I will be able to satisfy your lordships to convey that bona fides of the government are writ large, and from one or two suggestions which I will make, your lordship's conscience would be satisfied that scheme is designed to ensure that the ruling party knows it's not even the intention. The ruling party doesn't want. That's the stand of the government. Whoever is the ruling party should not know about any of the details which others are not knowing. Who donated, to whom, what amount, the ruling party should not know. And I will not point it out. And if necessary, my lord, I have some suggestion, my lord, which may, my lord, perhaps, my lord, subject to your lordship being satisfied, take care of your lordship's concerns.
Mr. Solicitor, is it your contention that under this scheme, the ruling party does not know who its donors are?
No. The party every party knows who their respective donors are.
Yes.
Yeah, my lord, the confidentiality is from other party, my lord. I'm sorry, my lord, I am unable to convey the heart of the matter. My lord, if I donate to Congress, the Congress knows Tushar Mehta has donated.
Right. But you don't,
My worry
you
is
don't want another party to know.
BJP should not know so that I don't get victimized. That's the purpose of confidentiality. My lord, technically I can say, my lord, Mr. Bhushan has given this example that even ruling party can, any party, my lord, why ruling party, any party can feign ignorance. That somebody came and in my Dropbox not in the digital sense, in the ballot box, in the postal box, there was an envelope. An envelope contained 100 crores. Nobody donates like this. We give money like this only in pilgrimages. People would not donate, my lord, anonymously. In Srinathji, my lord, people would donate 100 crores without any name. It would be an anonymous donation because that is, Tirumala. That's what I'm saying. But that is, my lord, again, idealistic way. Practically, the party.
Even that is not idealistic. Because the assumption is that the Almighty knows who has put money in the hundu.
Your lordship, I bow down, my lord. There is no confidentiality. My lord, even the person also knows why he is donating. That is reflection of the fact that there is a line in Ganges for, my lord, because they know कि बहुत पाप किए धोना जाना पड़ेगा. So people also know that. But, my lord, the party who receives knows who has given. That you can never, my lord, come out of. There cannot be any system where the donor and donee each other would not know.
But then, so Tushar Mehta, if this is so, why not make everything open?
But, my lord, then the purpose is defeated. As I, my lord,
As it is, everybody knows about, or partly knows about it, partly they know about it. Only person who is being deprived is the voter. Your contention that the voters do not have the right to know after the number of decisions of this court. It's slightly difficult.
No, my lord, voter, my lord.
Because they would know that, they should know.
Then I bow down and we go back to, my lord, the earlier policy.
No,
That's the only answer.
No, it's not like that. That's why we said we are not for a moment saying that, look, there are 3 or 4 considerations which are very important. One, the need to reduce the cash element in the electoral process. Very
It has
important.
reduced, my lord.
Right? Second, the need to encourage the use of authorized banking channels for that purpose, which
Correct,
is
ma'am.
the only way you can reduce the cash
Correct,
element.
ma'am.
That's the second consideration. Third, there is a countervailing consideration. Third is incentivizing the use of the banking channels.
Which is confidentiality according to us.
And therefore, according to incentivizing the use of the authorized banking channels should therefore result in greater confidentiality. But there is a fourth consideration, which is the need for transparency. And a fifth consideration, which is that this should not become a legitimization of kickbacks
Yeah, my lord.
and quid pro quo between
Correct.
the power centers, whether in the states or in the center, and people who are really in that sense, they are benefactors of that power. They are supplicants.
I
They
bow down.
yes.
I bow down.
So all these. So when the balance is drawn between these, of course, the balance has to be drawn by the legislature and by the executive, not by us. We are quite conscious of that. But it's not therefore that you have an either or. Either you have this or you go back to an entire cash system. You can design another system which does not have the flaws of this system, which really they put a premium on put a premium on opacity. You can still devise a system which balances out in a proportional way. That's the point.
I'll just.
How it is to be done is for you to decide.
Lord, I'll just.
We will not go step into that arena. That's no part of our function.
I'll just respond to Malod after showing the scheme, but let me respond the last point first, which is bothering your lordships. That this might be used as legitimized kickback.